Welcome to Legalese. My name's Christopher Lilly. I'm your host. Legalese is a presentation of the Northern Middlesex Bar Association. It's half hour in length, and it's designed to bring topics hopefully of interest to the public about the legal system, and it's centered in Middlesex County here in Massachusetts. I am joined today by attorney Karen Levitt. Welcome, Karen.
Thank you. Nice to be here.
Thank you. Thank you for coming.
Thank you.
Karen is an attorney with the Levitt Law Group in Chelmsford, Mass. Karen is a very experienced attorney, a very experienced litigator, but she is also experienced and trained in the system of collaborative law. And that's our topic for today, collaborative law. And Karen, I'm going to ask you to describe for us what is collaborative law.
Well, collaborative law is basically an out-of-court process where families who want to resolve various types of family law conflicts, divorce, paternity, child support issue, parenting plan issue, agree to resolve their conflict or their legal dispute using two lawyers. Each party has an attorney, and they agree that they're not going to court. So they're going to resolve their case outside of the courthouse doors. If they reach an agreement, they can file it with the court. But the whole concept is that the lawyers act as settlement counsel, and that the lawyers are really, they're not adversarial. So the focus is really on the lawyers being advocates for the clients, not being adversarial. Okay. And the focus is on settlement and resolution. So
we, in our system of justice, it's referred to as an adversarial system. And that's kind of the system upon which things are built here in the U.S. This has a component, or it's a little bit different than an adversarial system. In what way?
So, you know, the traditional court process that most people are familiar with, or that you watch on TV, or you may have experienced yourself, you know, you go to court, people are often standing on different sides of the room, or they're in a courtroom where they can't really speak. They may appear in front of a judge for a very short period of time. Someone else makes a decision for them. If there are two attorneys, they are generally on, you know, opposite sides, and they really are more adversarial, meaning they're taking positions that may or may not really, at the end of the day, benefit families, even though that's the intent. It's very positional, if that's the word I would use. In the collaborative law process, what the clients and the attorneys are really trying to do is focus on what is it we really need to solve the problems that we have here. What's the best process for doing that? Who are the best people that we might need to help us to get there? For example, a financial professional, a mental health professional, if you have a parenting plan you need to resolve. And can we do this outside of court in sort of a more respectful manner where we also have a little more control over the process? The focus of the lawyers is a little different. They have to shift their thinking because as a collaborative law attorney, and there is training to become a collaborative law attorney, part of the skill in doing collaborative law is really trying to understand not just your own client's needs or their concerns, but also the other parties. Because, you know, if you can understand where the other party's coming from, sometimes you find that people are not, you know, their interests are different or their priorities are different, but that can create some space for people to be able to talk about their problems and resolve them. Rather than being positional, you know, be taking a side, you sort of come together in a more transparent or open way to really try to, you know, problem solve. I guess that's a good description that I would give.
So you're not beating one side trying to beat the other side. They're trying to work together toward a resolution.
Yes. I mean, you're still an advocate for your client. You're under the same ethical rules to zealously represent your client. You're still trying to provide your client with the best result possible, but you're not trying to do that at the expense of the other party.
Exactly.
So, you know, and ultimately the family may benefit from that approach. I think sometimes it makes it easier for people to really talk about, you know, what their concerns are, and with each other to sort of get to, particularly if they have children, they may have a continuing relationship after divorce or after their conflict is resolved, have to still talk to each other. So having a process that sort of models that is a good thing.
So perhaps you could take us through the process of the collaborative practice, and what and we're talking in the context of family law. At the moment.
Correct.
There's also other other areas of law where collaborative law can come into
Yes, I mean,
into play.
there are some people who have used it in personal injury cases, in small business or partnership breakups, business partnership breakups, employment disputes. So it certainly can be used in the civil context, but it's largely, most people are familiar with it in the family law context.
So let's bring it back to the family law context. And in that context, how would an attorney, such as yourself, approach you have a situation that you determine is appropriate for a collaborative law approach? What are the various steps that one would take?
So normally, a client comes in to see me. If we determine that the collaborative law approach is a good one, we certainly are interested in having the other party want to do the same thing. So we will provide them with some information from some various websites that they can go to if they don't know anything about collaborative law. And we may give them some information about how to find a collaboratively trained attorney. Sometimes I might send a letter to the other party saying that this is the process we'd like to use. I might even send some brochures or some information about it. And assuming they get a collaboratively trained lawyer, what we then do is we sign what's called a process agreement. It's actually agreement between the parties.
Okay.
And the parties sign this agreement that says that they are agreeing to resolve their case outside of court.
Okay. Before we get into the agreement, what goes into deciding that this is an appropriate situation that would involve or likely involve the collaborative law approach?
So we tell our clients about all their options. So they have the option to do litigation, to do collaborative law, to do mediation. There's some other settlement processes they can also consider. Collaborative law and mediation sometimes sound very similar because they are both out-of-court processes. I think when we have a case, though, that you might have a case where someone wants to resolve a case outside of court, but maybe they're not really good at advocating for themselves, or they don't understand the financial issues in a case, and they're worried that in a process like mediation, which is a wonderful process, there's a neutral party in a mediation process that acts as the mediator. But generally in Massachusetts, lawyers don't go with people to mediation. So if you have a case where you have a client who's not going to be comfortable advocating for themselves in a mediation process where they don't have a lawyer present, again, they might understand the finances, they may feel intimidated for a number of different reasons. And so those kinds of cases are really very good, I think, for collaborative law because the clients are still interested in resolving it in a respectful way out of court. And so they're looking for an opportunity to do that, but not by themselves. So they get the support of a lawyer in the collaborative law process. And the collaborative law process also uses a number of neutrals that can be helpful, financial neutrals. You can use mental health professionals to help you with parenting plans. And it's a confidential process too. Like mediation, it's confidential. So sometimes people have issues that they really don't want to air in court. They prefer to keep them private, so it's another mechanism for doing that.
So is that part of the agreement, would be the confidentiality of the process?
So a process agreement for collaborative law includes the agreement not to go to court. It includes the confidentiality provision. It includes a reference to when people file in court, they normally have something called an asset restraining order that goes into place, which means people can still pay their bills and do those kinds of things, but they, clients in a court process can't go sell houses or liquidate assets. So in the collaborative law process, we respect that, so we put that in the process agreement. The other thing the process agreement talks about, which I just want to point out, the other component of collaborative law, besides the fact that it has two attorneys and that it's an out-of-court process, is that the lawyers are actually disqualified from going to court if the case does not resolve in the collaborative law process. So that's in the process agreement as well.
That's part of what the parties agreed to ahead of time.
Correct. So
if something breaks down, those attorneys don't get to follow the case. Why is that?
So the concept is, and I think it actually works really well, it's a very different focus when you're looking to, when you're problem solving or focused on resolution versus always thinking about what you need to do for trial. When you're litigation lawyer in the court process, everything is driven by, the possible trial. In reality, something like 95% of all the cases that go to family court never get to trial. So you spend all this time and money, for 5% of the time that you actually go to trial. In the collaborative law process, you really get to focus on, again, what documents do we need? What information do we need? the parties have more control over the process and sort of crafting their own resolution, you know, within the bounds of the legal framework. So it allows the lawyers to be completely in a different place and focus differently. And they're really acting as settlement counsel for clients. And clients don't lose their right to go to court. They always still have that right if for some reason the process breaks down.
Sure.
And the collaborative law lawyers are required to help them transition to whoever might represent them in court.
Right.
And like any process, I mean, it's not common. In fact, I would say it's rare that they do break down. Occasionally they do, but not very often.
So there's an advantage to the client, to both clients, I guess, in not having those attorneys follow them into litigation at that point.
Well, because you have the opportunity, because it's a confidential process that you don't have in the litigation process, to really talk about issues, again, in a more transparent, open way. You know, in litigation, people are always sort of, you know, doing this, holding things close to their vest. That doesn't always work, frankly.
Sure.
Sometimes sharing information is more useful, or really, you know, delving down what's beneath what people are really concerned about, or why someone wants to keep the house, or what they're worried about with their parenting plan with their children. And you don't always get that opportunity to do that in court. So I think, you know, people self-select themselves for these processes. So clients tend to want to have a place where they can talk about this stuff, which doesn't really happen very easily in the court process, and unfortunately.
I imagine a client would be less likely to share something that they may consider more confidential if they expect that attorney to use that against them in some future proceeding.
Correct. I mean, in the collaborative law process, any documents we exchange, you know, financial information, that kind of stuff, if the case did go to court, you know, would still be available. But for example, if someone makes a settlement proposal in a collaborative law case, and the case didn't work out, you can't then take that settlement proposal and use it against somebody in court. So there's some protections built into the process in that regard.
Not just by agreement, but also it's a public policy not to allow those settlement discussions to come in.
And you have a contractual, you've signed this process agreement, you've signed actually a contract. And the collaborative lawyers, although they're not a party to that agreement, they sign the agreement, we sign it, acknowledging that we are in fact the collaborative attorney, so that our role is really focused on settlement.
Interesting. So you mentioned at the beginning stages an attorney, you as an attorney reaching out to determine if another qualified collaborative law attorney, collaborative law trained attorney would become involved. What does that mean to be a collaborative law trained attorney?
So we have in Massachusetts, we have something called the Massachusetts Collaborative Law Council, and they do a 3-day training every year, so people can be trained in the collaborative law process and sort of how to think a little bit differently. You know, I still litigate because there's certainly cases that still need the courthouse doors, but it is a little different way of thinking when you're, you know, acting as settlement counsel. The collaborative law process is also an interdisciplinary process, so we have collaborative practitioners who are not just lawyers. We have financial professionals who are collaboratively trained. We have mental health professionals who are collaboratively trained. We might have a business appraiser who's collaboratively trained. So these are people who might be neutrals in a case and understand how to work with a couple, you know, not as hired guns, but together. So the training really, you know, is both educational, experiential, and then there's also advanced training. The Collaborative Law Council does several advanced training programs every year, and there's a continuing education requirement. There's also an international collaborative law organization called the International Academy of Collaborative Professionals, and they have an annual conference every year, which is several days. So there are many of us from Massachusetts that go to that every year and continue our education in the collaborative law process. And
now you were involved in some of the collaborative law committees yourself.
Correct. For the Massachusetts organization, the Massachusetts Collaborative Law Council, I was a past president, one of the founders of that, and served on a number of their committees. I'm currently on the board of directors of the International Academy of Collaborative Professionals, and I chair one of their task forces, which is about access to collaboration, which is educating and bringing this process to people of either no means or people sort of a more modest means. So finding ways to streamline the process a little bit to understand that, you know, people have limited funds for any of these processes. So working with people to really try to figure out a way to how best we can do collaborative law, regardless of the client's financial resources.
And that's a kind of an access to justice approach that,
Yes.
that you're taking.
Right, because I mean, I think there are many more people who represent themselves today
Mhm.
in court.
Mhm.
I think by necessity, not because they necessarily want to. And so, the collaborative law process is certainly something that's available to all people. And part of what our task force is working on is, again, trying to sort of be creative about the way we do collaborative law
Mhm.
so that it can meet the needs of people, again, with all sorts of differing incomes. And, the International Academy of Collaborative Professionals also, they have a grant program where they fund grants to various communities. Massachusetts actually got one last year. The Massachusetts organization applied to the international organization and got a grant to do a video and some that could be shown to clients about collaborative law and to educate, and also to do some more training for professionals. So,
off the top of your head, any resources that you might recommend as far as people looking into?
I can give you the website information if that's
Okay,
helpful.
sure.
So the Massachusetts Collaborative Law Council is www.massclc, that's MASSCLC, that stands for Massachusetts Collaborative Law Council.org. And they have lots of information for the public on there. They also have a list of their members who are all collaboratively trained lawyers. And then the International Academy of Collaborative Practitioners is www.collaborativepractice.com.
That's one word.
That's collaborative practice is one word,
Yes.
and .com. And they have a great website too, and they have lots of information for the public. They have a public section. They have a section for professionals, but a section for public. And there's actually a really good video on there, which is of a Canadian couple who used the collaborative law process for divorce. And you have to just, keep that in mind that it's a Canadian couple, which has a little different laws than Massachusetts. But, they describe why they chose collaborative law, what it was like to go through the process, how they thought it benefited their family. And it's actually a really interesting video. So if people are interested in collaborative law, that's a great place to just go hear from, some people who actually use the process to see what they think.
So let's get back to the process here. As far as you've signed the agreement, you're going forward, and you're now approaching this from the collaborative law approach. Now you referenced some professionals.
Correct.
Financial professionals, other professionals, whether we're dealing with doctors or what.
Sure.
What are we talking about by way of other professionals that you might have involved, and how do they become involved?
So I'm going to just quickly describe an agenda for the very first meeting in a collaborative case, because that might help answer that question, if that's okay. So very first meeting, we might sign that agreement I was talking about, but we also have an agenda where we talk about what professionals would we need, what documents do we need to exchange, what are the issues here. So we really try in that first meeting to sort of lay out the case a little bit for all of us. But different kinds of professionals we might use. A financial professional is just one example. So sometimes we'll send the clients on their own, not necessarily with the lawyers. They don't need to pay us to be there, to go meet with a financial professional to help them fill out their financial statements that they have to fill out for court, to help them figure out what all of their assets are. If there's tax issues, to help sort that out, to understand differences between alimony and child support. Sometimes we can use a joint financial professional to really lay out all the financial issues in a way that makes sure we covered all the bases. And so at that second meeting we might have, we could either have the financial professional come with us and join us, or give us their material that they prepared, so that we can discuss the issues. But that way, we've had someone who's experienced and knowledgeable and an expert at those issues sort of frame everything for us, put it in a nice little package for us so we can talk about it. Business appraiser is another one. We've had a couple cases where we have, you might have a doctor or even a lawyer who has a business, and the business has to be valued for purposes of a divorce case. So we use a business, and sometimes in those cases only one of the parties is the business owner. So you have one spouse, husband or wife, who's the business owner. You got the other one who really may not understand the business. And so this neutral business valuator that becomes part of the collaborative law process, meets with both people, talks to both of them, and can come to a meeting, give us their report, explain it to all of us so we understand it.
How do you choose that neutral individual? Sometimes someone may consider this person well, you know, that person's going to come in high, that person's going to come
Yep.
in low, and they're different. So what kind of approach might
So
you take for that?
it's a joint decision. So usually the lawyers will come up with a couple of names. Many of these collaborative professionals are willing to either be on speakerphone at a meeting or have the clients call them. So so they can sort of interview them, so to speak, and then pick the person that they want. So they have input into who they choose, what the cost might be. So it's kind of a nice way to do it. And some of these folks actually are willing to meet with our clients so they can, if they want to interview them in person,
Okay.
they will actually, some of them will willing to meet with them to kind of help people make those choices.
Okay.
But we do guide them as lawyers, obviously, and to sort of come up with the names of the people we think might be best for what they need.
Okay. All right. What are some of the other professionals that?
Oh, we've used, again, we've sent people to, we've had some cases where we've had people where there's alcohol or drug problems.
Okay.
And so we've used a psychologist, or called a child specialist, where the parties have come up with a safety plan. Someone may have a problem, but, is in remission or is, doing well, but people are concerned about them not, maintaining that. So we've actually had some professionals meet with the parties to create safety plans for kids.
Okay.
We have used vocational consultants. We have someone who's trying to get back in the workforce, and how to do that. It has no idea. May have been a stay-at-home mom or dad. So we can refer them to a neutral who might help with that kind of thinking or help resources. We've sent people to financial planners. We've used estate planners. Sometimes we have cases where there might be a people who get the divorce, for example, are close to retirement age, might be concerned about their retirement, and they want to they're getting divorced, so they're going to have less money to retire with.
Sure.
Because they're dividing what they have. So they might want to consult with, or we may jointly consult with people who might help them think about, post-retirement. So we've used many different kinds of professionals, real estate brokers, anybody really that you might need for whatever reason. And not all cases need anybody. I don't want to miss,
Sure,
people need to understand
sure.
that these are, every case, has its own set of facts and needs. So we have cases where we don't, it's just,
You may not need professionals at all to be involved. It's smaller.
Right, and a lot of our cases, in Massachusetts, our best practice for collaborative law cases is the use of a case facilitator who's present during the meetings, which are at lawyers' offices, and that's often a mental health professional who can help, address the emotional component of divorce or whatever family law conflicts people have. It can be a guardianship. It can be putting mom or dad in a nursing home. All the emotions that go with that. So we sometimes involve a case facilitator who helps us kind of stay on track and not get too distracted by those pieces.
Is a case facilitator involved in all cases, or just if you feel it's appropriate?
In Massachusetts, it's best practice to have them, but they're not required. So again, I think when we talk
What are they? What do they do?
They usually will meet with each person before the case starts, and they will try to learn a little bit about their situation. They might want to understand how they communicate with each other, or maybe how they haven't communicated with each other. What kind of their hot buttons are, because what they're kind of, we want these meetings to go well and to be productive. So their job really is to, gather information about people's goals, what the emotional components might be, and then at a meeting pay attention to those. Let the lawyers do their lawyering job.
Sure.
But let them pay attention to or help people manage the process. It's a pretty painful process for people. These meetings, are difficult. So the case facilitator can really help with that. Sometimes they'll meet with people. They can be used to help with parenting plans. So some of our clients will meet with them, again, not with the lawyers present, just privately with the case facilitator, work on their parenting plan. And they're not always at every meeting. Again, that's a decision that the clients and everybody makes. And some of the things we're looking at for, I talked earlier about streamlining the process for, each individual case, so that depending on what people's needs are, what people's resources are, making those decisions about, I think it's helpful to have the case facilitator on board at the beginning, at least for the parties to meet with them and maybe be at their first meeting, where we sort of lay out and sort of plan the case a little bit.
Okay.
And then, again, many times they're there for the entire process.
Okay.
So.
All right. Now, you mentioned a situation that might involve use of drugs, and how
Yeah.
a person might, you may need to get professionals involved with that. Do you find situations where there might be somebody at risk? Are there situations that you may find are inappropriate, I guess,
For collaborative
for
law?
collaborative law?
So, there are cases I think that would be inappropriate. I think if people have significant mental health issues, for example, I mean, they may not really have the capacity to participate in the way you might want them to in a collaborative law case. I think if people have, are very active substance abusers, that could be problematic. I think it kind of depends on the case, I guess, how functional people might be. If there's domestic violence, so if there are restraining orders, we have done collaborative cases where there have been restraining orders, but you sort of have to, I think you would assess a case for whether it's appropriate to do it in the first place.
Right.
And if you think it is, everybody would have to agree that it was. And then you might establish certain, safety planning around that for a meeting, or you could meet you might meet in a courthouse. You could come up with a lot of different ways to address that, just depending on the circumstance. So, and there are cases where people just there's some cases where people just have unreasonable expectations, and so you're just not going to, you're not going to resolve it in a process like mediation or collaborative law.
Sure.
It may, when I said before, there are cases that need the courthouse doors. That just, there are just those that do.
They need the day in court, I
They
guess.
need the day in court, or they need the intervention of a judge in a different way. So, and we do, when people come, we assess that and talk to people about it. It's, at the end of the day, it's up to the client for the most part. But.
How do people get hold of you?
Well, they can call our office, which is 978-458-5550. They can look at our website, which is www.levittlawgroup.com, and that was one word. They can also email me, which is klevitt@levittlawgroup.com. So.
And I found Karen's website very, very helpful as far as content and explaining collaborative law in the context of litigation and mediation as well. And I want to thank Karen for joining us here tonight. I think this has been very informative on the area of collaborative law, and I want to thank you all for watching here. As I instruct at the end of every program, please, if you have every set of facts is different. Your set of facts, you should not make decisions based upon what you're hearing here tonight, but you should approach local counsel, talk to local counsel. That's what they're there for. Bring your situation to that attorney's attention, and hopefully they can help you through that process, as I'm sure Karen can. And again, thank you, Karen.
And thank you for the opportunity to talk about collaborative law. I enjoyed it. Thank you.
Good. Thank
Okay.
you.
Okay.
All right. Good night.